Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 24th of April, 2025, Judge Stephen J. Hippler rendered an order concerning multiple of the State of Idaho's disclosed witnesses that the defense was either seeking to have stricken from providing testimony or having their testimony limited at trial. The court denied all, however, left open the door that the defense was free to raise objections, i.e. at trial, and that the court would entertain them at that time. Two of the expert witnesses involved here appear at page 5 of the order, Heather and Jared Barnhardt. There's a footnote 9 next to their names, and it says here, the state submitted the following disclosures for the Barnharts. Initial disclosure, Heather Barnhardt. Initial disclosure, Jared Barnhardt. Rebuttal disclosures, Heather and Jared Barnhardt. Their rebuttal disclosures says that the Barnharts intend to rebut the expert testimony of Carol Pendon, Kevin Pendon, and Josiah Roloff, but need additional information prior to offering rebuttal opinions, and that the defendant is not challenging these. The body of the opinion begins by saying the Barnharts are digital specialists with Cellbrite, who were retained by law enforcement to analyze defendant's cell phone and PC to determine, quote, user behavior and actions, end quote. They are disclosed to opine that the gaps in data on the two devices were, quote, abnormal. And there's a corresponding footnote 10 here saying, specifically, their report explains that the gaps in data may be consistent with, quote, cleaning up or using anti-forensic methods to clear evidence, end of quote. So this testimony may have something to do with alleged spoliation, cleaning up of evidence regarding a digital footprint. Body of the opinion continues. Attached to the disclosures of report jointly authored by the Barnharts, detailing their analysis and their findings, and their CVs were provided as well. CV is short for curriculum vitae. What's not listed anywhere in this order is that in addition to the requirements that both sides have to provide discovery, including expert witness discovery pursuant to the Idaho Rules of Evidence, Judge Hippler on October 9, 2024, also issued an order governing expert witness disclosures, and one of the things that both sides were required to produce to each other when disclosing their expert witnesses were their expert witnesses' curriculum vitae or resumes. This order continues. Defendant argues that the disclosures indicate they will testify to, quote, habit evidence, which he complains is not explained and is not accompanied by any opinions. Defense's challenge is confusing. Nowhere do the disclosures or the report indicate the Barnharts will testify about, quote, habit evidence. Rather, the disclosures state they will testify to their findings pertaining to defendant's activities on his PC and cell phone for a period of time before and after the homicides, and why gaps in data over that time period, quote, are abnormal, end of quote. The Barnharts' opinions regarding these topics are fully set forth in their joint report. For example, they observe gaps in defendant's school PC that may be consistent with cleaning up or using anti-forensic methods to clear evidence, citing to the Barnharts report. And then amongst these gaps found were in the PC's event logs and system resource usage monitoring between November 11th and November 16th, 2022, which the Barnharts opined was abnormal given that school was in session. Likewise, they located gaps in the PC's Chrome history during dates where downloads occurred on the system, indicating the user was private browsing or clearing browsing history. Together, the Barnharts' disclosure and joint report set forth all that is required by ICR 16b7, that's a rule of evidence, and there is no basis to exclude or limit their testimony. Thus, they will be permitted to testify at trial. This is Kathy. Thank you for joining us here today.